with specificity to underscore the preamble, the republic, the executive, the judiciary, the commissions, amongst others. Let me just explain some of them. Let us look at the executive. What is the nature of the executive in Kenya? It is pure presidential. What did the BBI bill seek to do? It sought to create a hybrid presidential and parliamentary system where we'll have a president and a prime minister. That was a fundamental change. It amounted to an alteration of the system of government which the people of Kenya had said will govern them. What about the legislature? The system of the legislature in Kenya underscores separation, where elected members of the National Assembly and the Senate cannot be part of the executive through the cabinet. A well thought out entrenchment. What did the BBI bill seek to do? It sought to fuse the executive and the legislature by ensuring that the president has the power to appoint cabinet ministers from the legislature. Again, a fundamental departure from that which the people of Kenya had agreed upon. What about the judiciary? The judiciary is supposed to be independent and accountable. The process towards this entrenchment was a long process. In this BBI bill, an ombudsman, who I call the prefect of the executive, sought to be put within the judiciary. Again, a fundamental departure. To that extent, it is my humble submission that I have indicated the extent of the application of the basic structure and to what end that basic structure was to be interfered with through the BBI bill. Now, whether the basic structure of the Constitution can only be altered through the primary constituent power. The word alter was specifically used by the High Court and the Court of Appeal. All the judges of the Court of Appeal created a clear distinction between amendment and alteration. I believe, therefore, there is merit in the framing of issue number 1 by putting the word alter, and in issue number 2 by putting the word amendment. It is my answer that the basic structure can only be altered through the primary constituent power. This therefore begs the question, what is the primary constituent power? Where did it emanate from? Is it textualized? The argument put forth by the appellant is that this constituent power is non-existent. It's not textualized. And that if the people of Kenya wanted it to be part of the Constitution, nothing would have been easier than for them to say so. Now, constituent power traces its origin to antiquity in constitutional jurisprudence. You will find it in the written works of John Locke. You will find it in the written works of Charles Montesquieu. But permit me to pick what a recent writer has said about constituent power. A book written by Professor Justice Ernest Wolfgang, titled Constitutional and Political Theory, traces the origin of the constituent power. At page 169, the problem and concept of the constituent power, he says, the constituent power is the basic legal order of the polity, the basic legal order of the polity. But whence does the legal constitution derive this special validity and agency? After all, it does not exist simply by virtue of itself as an irreducible primordial phenomenon. Irreducible primordial phenomenon. He proceeds, it derives its claim to validity and its special legal quality, if not from the mere fact of its creation, from a preceding entity that presents itself as a special power or authority. Ever since the French Revolution, that entity as the constitution-making power is referred to pouvoir constituant. And then a further definition is given at page 172. And this is what Justice Professor Wolfgang says. It was developed first in 1788. 1788. So when somebody tells you it's emergent, it was picked from nowhere. That is what Justice Kiage says. Those are alternative facts and misrepresentations of the law. Now, let's look at the definition given by Professor Nubweze on what this constituent power is. Writing on presidentialism and constituent power, this is what Nubweze says at page 496 of volume 2. And it's fundamental because of issue number 2. Recalling again that the president under the presidential system in Commonwealth Africa is the organ that coordinates and therefore dominates the executive and the legislative process of government, a question is asked. A question is asked. Does the president also assume constituent power? And then he proceeds to say, the nature and importance of the constituent power need to be emphasized. It is a power to constitute a frame of government for a community, and a constitution is the means by which this is done. It is a primordial power, the ultimate mark of a people's sovereignty. Professor Nubweze elaborates the manner in which that power is exercised, and you'll find this at page 511 of the same volume. He sets out 4 sequential steps. 1, the framing of proposals for a constitution. 2, popular consultation. 3, formalized discussion. And 4, plebiscite, aka referendum. What my colleagues have told you is that under Kenya's constitutional jurisprudence, the only avenue for people's participation is through the referendum. No, that cannot be the case. The 4 sequential steps stressed by the court emanate from this elaborate pronouncement, this clear writing on what has to be done. If you proceed to read that particular chapter, that elaboration is emphasized as the dichotomy between the actual and strict power of amendment and the repeal power. Now, permit me also to look at what Professor Yaniv Rosnai has said about constituent power. Yaniv Rosnai, in his book, Unconstitutional Amendments, The Limits of Amendment Powers, writes as follows, commencing from page 105. He says, constituent power is the power to establish the constitutional order of the nation. It is the generative principle of modern constitutional arrangements. And then he proceeds to define further what the constituent power does. And he proceeds to say, it has the framing power, the establishing power. You'll find this at page 120 of that book. Now, we have seen what the basic structure is. We have seen the extent of its application. We have seen the manner alteration of the basic structure. And it is for that reason that we must answer this question. Because my learned friend James Orengo said, what is this doctrine? Is it like a stone that we just have to kick it and see it? No, it is not as nebulous as presented. Because if it was so, then there will be a demand upon the court to locate from the Constitution independence of the judiciary, separation of powers. It is for that reason, therefore, that these concepts are called basic concepts. It is like the ABCD, it's like the ma, me, mi, mo, mu. If these concepts cannot be appreciated in the most simplistic words, then there can only be two conclusions. One, a deliberate intention to mislead the court on the application. Or two, failure of understanding of basic concepts. As to which of those two this relates, I will leave it to the court. I will allocate 8 minutes to issue number 2 and leave the rest to my colleague Esther Ngawa. Whether the president can initiate changes, stroke amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution. Let me answer that question with a lot of simplicity, and the simplicity is derived from the nature of the Republic under the Constitution. Now, under Article 1, the sovereignty of the people has a trichotomy of Parliament, which is the legislative arm of government. Then we have the national executive, which is the executive arm of government, and we proceed to the judiciary. What is key to us are two, and we'll find this in Article 94. What is the role of Parliament? The role of Parliament is set out under Article 94 thus: the legislative authority of the Republic is derived from the people and at the national level is vested and exercised by Parliament. You proceed to item 3. Parliaments may consider and pass amendments to this Constitution. Pass amendments to this Constitution, not alter. And for this purpose, I must emphasize, the word alter appeared in the 1963 Constitution. It appeared in the 1969 Constitution. It has disappeared in the 2010 Constitution. Now, compare that with the power given to the President under Article 131. The President, B, exercises the executive authority of the Republic. 2A, the President shall respect, uphold, and safeguard the Constitution. Nowhere in the Constitution will you find any indication of the power to initiate amendments on the part of the President. It's nowhere. And if we may go back to Professor Nobweze, he has made it quite clear that the moment the constituent power has been exercised and the Constitution has been birthed, the individuals in office must exercise the power given to them under that Constitution. Should they seek to alter, they must go back to the people, and they must do that through the 4 sequential steps. The President cannot be President and at the same time be the people. He can't. And if any clarity is required on that issue, we go back to what Justice Professor Wolfgang said, and you'll find this at page 172 of his book. Its goal, the goal of the constituent power, was to counter the king's sovereign powers grounded in law and tradition, and the institutions of the monarch with the original and unbounded political decision-making power of the nation as the force that brings forth the Constitution. Let me simplify this thing. What you're being asked to do by answering this question in the negative is this: to constitute Kenya into a monarchy or to constitute Kenya into an oligarchy. Kenya is the democracy. It cannot be done. Let me close that argument with an extract from Professor Nobweze, who demystifies that which my colleagues here want to complicate. Nobweze has dedicated an entire chapter on he has dedicated an entire chapter on the power of the president and the limitations to that power. If I may take you back to volume 2, and this one is titled The Office of the President. And the operative extract will be found at page 482. And this is very important, 482. Aside from his legal immunity from suit and from insult, you cannot insult the president. If you think you are equal to the president, just insult him. You will see what will happen to you. Equality is hardly apt to describe the social relations of an African president. Inequality is a necessary feature of the African society. And then he closes by this depiction, which you'll find at page 483. Splendor is indeed part of the social preeminence of African presidents. You'll not find them riding a bicycle like the French president, Macron. You'll not find them eating a burger like the American president, Obama. No. Personifying the state, writes Arthur Lewis, they dress themselves in uniforms, build themselves palaces, bring all traffic to a standstill when they drive, hold fancy parades, and generally demand to be treated like Egyptian pharaohs. Can I bring the traffic in Nairobi to a standstill? Can I build a palace for myself? Can I demand to be treated like an Egyptian pharaoh? No. And with that, a conclusion must be made. If the president is immune, if the president is supposed to protect the Constitution, the president has no role either in the popular initiative or in the parliamentary initiative by way of initiation. He can't. It must be left to the people through the constituent power, or it must be given to the people's representative, the constituted power, which is parliament. Hence, the clarity in those two initiation processes. If there is anything that I have not said, I will answer it in the question, should any be asked. There is something that I must speak about. Veiled threats have been given to the court that you must not interfere with what the president has done, because the president gets information that is not available to you and I. The president knows who are the enemies of state. Look, if the president decides that Nelson Harvey is the enemy of state, and I'm disappeared, I'm abducted, and these things happen daily, we can't question that? No. The president is not the king. The president of Kenya is not a pharaoh. The president is a servant of the people of Kenya. He exercises delegate executive power, and he must be brought to check if he veers off. And fundamental to that premise is this: the president cannot say from one side of his mouth that I'm an ordinary citizen entitled, just like Wangare, Omondi, and Wafula, to initiate a popular initiative towards constitutional amendment, and at the same time say, no, I'm immune from everything, including a transgression of the Constitution. Yesterday, Chief Justice Emeritus, responding to the comments on Twitter that there is maximum security at the Supreme Court, said this: why can't this security be used towards the enforcement of court orders? My ladies and my lords, let me be frank to you. What is being prepared is synonymous to the 1985 palace siege of the Supreme Court in Bogota. That is how it started. If we can't get this, we must threaten you with this. You must not succumb to the threat, which is a veiled threat, that behold, here you are enjoying immunity as judges. Why are you not giving me similar immunity to do that which I must do? For the people of Kenya, exercise the judicial authority delegated to you without fear or favor. And here comes the dirge by Emperor Haile Selassie. You're better off dying standing than living kneeling. Do not be forced to kneel to the caprice and the oppression of those who find the Constitution as an inconvenience. I urge this court to dismiss the appeals by the first and second appellants, and to some extent consider that part of the third appellant's appeal that is in consonance with the general framework of our argument from the High Court to the Court of Appeal. I thank you most sincerely.
Good afternoon, the Honorable Chief Justice, the Deputy Chief Justice, my lords and my lady, Justices of the Supreme Court. My name is Esther Angawa. I'm led by Mr. Nelson Harvey for the first to the fifth respondents. ETOPS, ETOPS. A few days ago, Mr. Harvey told me a plane cannot fly with one engine. I didn't take his word for it. He's not a pilot. So I conferred with Captain Wicks Rabach, a military army captain, and now a commercial airline captain for more than 10 years. He laughed, he said, yeah, it is true, a plane cannot fly on one engine for too long. It's a basic principle. It's ETOPS. Engines turn or passengers swim. Engines turn or passengers swim. That's the informal for extended range twin engine operational performance standards in airline lingo. In short, the ETOPS rule, currently 240 minutes in the US, is the amount of time that a twin-engine aircraft is allowed to fly along a flight path that is far from an adequate airport. So that if a 2-engine aircraft chooses a flight path that goes beyond 240 minutes, and that's in exceptional circumstances, ordinarily it would be 180 minutes, that's 3 hours, there's a problem. Because should that plane lose one engine, it would not make it to the nearest airport and land safely. Engines turn or passengers swim. It is our submission that the IEBC is a twin-engine aircraft. Article 88, sub-article 5. The Commission shall exercise its powers and perform its functions in accordance with the Constitution and national legislation. The 2 engines of the Commission. In the interest of time, my lords and my ladies, I know you have read and you will continue to read. I will not spend as much time on all the decisions that have been cited to you. But I would like us to use this basic airline principle to understand why this honorable court must interpret Article 88 and Article 250 sub-article 1 in the manner they were interpreted by the Superior Court and the High Court, and not in the manner suggested by the Commission. Composition of the IBC is at least 3, a maximum of 9. Composition defined in the Chambers Dictionary thus: composition, the act or act of composing. Compose, to form by putting together or being together, to set in order or at rest. The Constitution constitutes the Commission by giving a minimum of 3 and a maximum of 9. In compliance with Article 88(5), Parliament enacted legislation, the IEBC Act, which the second engine set the specific composition of the Commission now at 7. The marginal note in the IEBC Act speaks to composition and appointment. Quorum is relegated to the schedule. Had the drafters of the IEBC Act and even the Constitution intended that the composition of the Commission be equated to its quorum, nothing would have stopped them from doing so in the Constitution or in the section that provided for the composition of the Commission in the IEBC Act. This is the definition of quorum. The legal definition of quorum under the Black's Law Dictionary, I'm referring from the 9th edition. Quorum is defined thus: in parliamentary law, the minimum number of members, usually a majority of all the members, who must be present for a deliberative assembly to legally transact business. That is the definition of quorum. Now, what is the definition of majority? This is the definition of majority under the Black's Law Dictionary: the status of one who has attained the age of 18,
the relevant definition being the second, a number that is more than half of a total, a group of more than 50%, a majority always refers to more than half of some defined or assumed set. So that if this court were to be convinced to follow the request by Professor Githu, that where the paragraph on quorum is deleted, we must go back to the Constitution and rely only on the Constitution, our one engine for the commission, because the second engine has failed. The Constitution sets a minimum of 3. He says, on behalf of the commission, that they can go ahead and conduct business. Would quorum with a membership of 3 be 3? Based on the definition I have read to the court, absolutely not. A majority of all the members being 3 would be 2 commissioners. Now, I would urge the court to read paragraph 74 to 77 of the judgment of Justice Chacha Mwita when he was dealing with that conundrum, because then the quorum had been reduced to 3, and he was looking at those provisions that had reduced the quorum to 3, and saying then, with a membership of 3, because then the commission had only 3 members present, 4 having resigned. Would a legally binding decision of the commission be made by the majority, being 2 commissioners? And what effect would that have on the performance of the commission in its objects as stated in the Constitution and in the IEBC Act, Section 3, subsection C, 3C, 31C. And the basis of the judge in holding that that amendment reducing quorum to 3 was unconstitutional, and a similar amendment to paragraph 7, which said that should the commission fail to reach a unanimous decision, then the decision of a majority of the members present and voting would bind the commission, which paragraph was also deleted. Meaning now that one engine has completely failed. Even if we were to say that the commission has 3 commissioners and is properly composed, as according to the Constitution, what happens where a unanimous decision cannot be reached by the commission? Would the commission make legally binding decisions by its majority of 2? Justice Okwany saved the commission, qualifying the reason for doing so by creating a dichotomy between what she considered a policy issue and routine administrative issues that the commission that did not need commissioners to make decisions based upon. And that is the only reason that the judge gave for allowing the by-elections which were in issue to proceed. But that judge, including the judges of the High Court and the judges of the Court of Appeal, decried the failure to replace the commissioners who had resigned. And that is where the extended range comes in. The period provided under the IEBC Act, our twin engine, is that, look, the commission, our twin engine aircraft, has lost one engine and needs to get to the nearest airport to land. Otherwise, passengers swim. And so the court, in its wisdom then, allowed the commission the comfort to proceed. I believe in the hope that the provisions of the IEBC Act relating to replacement of the commissioners would be followed and the appointments would be made. That was not to happen. Now, my lords and my ladies, you have been told to ignore the fact that no appointment were made until over 4 years later. The plane crashed because the second engine, the Constitution, could not get the IEBC to the nearest airport for landing. The IEBC is now fully constituted. And it is my view that that is probably because of the determination by the High Court relating to the invalidation of the administrative procedures that it sought to rely on, which were made without it having all its commissioners on board. Were that not to happen, who knows? We would be flying straight towards a general election with one engine nearly dying. I urge this court not to unsettle the holding of the Court of Appeal. And most importantly, because that holding relates to an invalidation of the administrative procedures, and if the court allows me, I would like to read it. This is what the holding of the High Court was. A declaration is hereby made that the administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null, and void because they were made without quorum, in the absence of legal authority and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Uphold that declaration, my lords and my ladies. Because what is in challenge here is that declaration, not the decision of Justice Chacha Mwita. This is the holding of the Court of Appeal that touches on quorum. The Independent Electoral and Boundaries Commission does not have the requisite quorum for the purposes of carrying out its business relating to the conduct of the proposed referendum, including verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution. The IEBC has told you, if you cannot disturb the findings of quorum, if you cannot disturb the findings on quorum, then please circumscribe all the actions by the commission prior to the making of the determination by the Court of Appeal. With all due respect, my ladies and my lords, we do not know what those actions are. Those actions have not been challenged before any court, at least not within our knowledge, and not within the court's knowledge, what actions are these? Where have they been challenged? And as His Lordship, Justice Tuyot said, this decision the declarations take effect at the date of judgment. I have indicated that what has been invalidated by the Court of Appeal on the basis of quorum is the administrative procedures and all the acts relating to the referendum. There is no basis upon which this court can protect certain actions that we haven't been told about. I urge you dismiss the appeals by the first and second appellant.
Thank you for your submissions. We'll move now to the next set of the respondents. The Third Way Alliance and all the persons who filed under Third Way Alliance. You recall yesterday, Filista Wakesho was given 15 minutes out of your time, so you have 45 minutes.
Thank you, Honorable Chief Justice. My name is Elias Mutuma. I appear for the 7th, 8th, and 9th respondents. I appear alongside Counsel Caroline Gerono. For the record, my lady, we have filed our submissions dated 9th of December 2021 and a case digest dated 21st of December 2021. I will be tackling 3 issues. One is the nature of a popular initiative and whether it is available for use by the President or the state. I'll also tackle the issue of public participation in as far as a popular initiative is concerned. My lady and my lords, I am persuaded to rely on the words of Shakespeare, who says that a rose by any other name shall still smell as sweet. I wish to add that a skunk in the same measure by any other name shall smell as bad. My lord, this initiative that has been brought to your attention has been branded a popular initiative. There is no name changing that is going to change the character of this initiative. It remains a skunk. It remains a presidential initiative as opposed to a popular initiative, and I'll demonstrate that as we proceed. It is our submissions, my lady and my lords, that the President is expressly prohibited from pursuing a popular initiative as a means to amend the Constitution. I will be supporting that argument with 2 grounds. One is the fact that sovereign power belongs to the people. This is captured under Article 1 of our Constitution, where the people can exercise that power directly or indirectly. A constitutional change process is a legislative duty, part of the sovereign power that the people can exercise. They either exercise that legislative duty directly or indirectly. In some instances, the people have donated that legislative duty to Parliament, and only Parliament, not to any other person. At no point have the people donated or delegated legislative power to the President. So if the President then purports to exercise legislative duties, then he's going against the delegated powers. His, we submit, is exercise of executive authority. It has nothing to do with legislation. Now the people have delegated legislative duty to Parliament in matters amendment of the Constitution under Article 256. That is very express. They have retained the exercise of the direct legislative duty to themselves under Article 257. At no point do we see, right from chapter 1, in fact from preamble, to the last chapter of the Constitution, the people delegating or giving away that legislative duty to the president or any other person. So then when the Attorney General argues that there is nothing wrong with the president initiating a popular initiative, then they must tell us from where does he derive that authority, because it is not under the Constitution. Article 1 of the Constitution, again, is very clear that that power is exercised directly or indirectly. And my point is, the words used are either or, so that when the people exercise direct authority to legislate, then there is no other body that can exercise that power on their behalf. The words used are either or, not both. The provisions of Article 131, and I want to address my landed senior, Mr. Kamau Karori, do not include legislative duty. The president cannot seek refuge under Article 131. In fact, from 129, 130, 131, and 132, to purport to exercise executive authority in a manner to change the Constitution. Executive authority is the power to govern. It is not the power to legislate. So what Article 129 to 132 provides is for the president to govern. Legislating is not provided for under those articles. So he cannot act as a symbol of national unity and then purport to legislate. It would be usurping the role of the legislature. And by this I mean legislature, either Wanjiku herself or Parliament. There isn't any other person that can legislate. Indeed, if the president was to be allowed then to initiate a popular initiative or in any other way legislate, that would amount to acting ultra vires by going against the doctrine of separation of powers. Again, I emphasize that legislative must be distinguished from exercise of executive authority. And in case we have any doubt, my lady and my lords, as to what it means to legislate, a first-year law student knows that legislation is the process of enacting into law. And enacting is a process that begins at the point of framing or drafting the proposed law and will culminate with approval of that law. There are quite some processes in between. Therefore then, the person who enacts a law must be the person who frames a proposed law. So if the president frames, conceives the idea that we need to amend the law, then it is him who is enacting that law. When you look at Article 255 of our Constitution, and allow me to read, my lords and ladies, is that it provides as follows: a proposed amendment to this Constitution shall be enacted in accordance with Article 256 and 257. The word used is enacted, and approved in accordance with Clause 2 by a referendum. we therefore must interrogate what does it mean to enact, so that when the Article 257 provides for the people to enact an amendment to the Constitution, it means, number one, they must be involved in the process of preparation and formulation of the proposed law. That is the first step. If they are not involved in the process of creation, formulation of that proposed law, then they are not involved in the process of enactment. The second phase of enactment is creation of awareness and consultation. In the case of Parliament, a bill is sponsored by a member of Parliament. It is introduced to the House through the first reading, and this is where members of Parliament get to interact with the proposed law. Now, in the event of a popular initiative, the question that we should ask ourselves is, did the people formulate the proposed amendment? Because you've been told by my learned friend, my good friend Jackson Awele and Arnold Oginga, that what preceded the collection of signatures did not matter. That it doesn't matter that the people did not formulate, did not prepare is content deliberation. In legislative terms, when it comes to Parliament, that is called the committee stage, where now the issues are brought before the members of the Parliament. They deliberate over the content with a view of persuading each other on whether we need to retain certain content or remove them. Now, at what point did the people, in exercise of their direct legislative duty under Article 257, undertake this process? You will not find that anywhere. Instead, what you're being told is that it is enough that the people will have an opportunity to vote at a referendum. And we have seen Article 255 talks about enactment and approve by way of a referendum. So how then are they exercising their legislative duty if they are not involved in these processes? The last process is the adoption of the proposed law or referendum, which happens even in Parliament. They must take a vote. Now let me pause and ask you a question, my ladies and my lords. Suppose a bill is brought to Parliament from God knows where, and it goes straight to the third reading, and members of Parliament are asked to vote for it. If they vote for that proposed law, will it become a proper law? Have they enacted that law? The answer is in the negative. That is what the appellants are telling you, that we should not worry about where that bill is coming from. We should not worry about the level of our participation. Ours is just to endorse. Then we will not have enacted that law. We will have endorsed but not enacted, contrary to Section 255, 256, and 257. I make this submission because, looking at the nature of a popular initiative, once IBC is presented with 1 million signatures and a draft bill, there is no chance of in any way altering the contents of that bill. It proceeds to the county assemblies, National Assembly, Parliament, that is the Senate, to the President, and back to IBC, which presents the bill to a referendum. So then, if it doesn't matter what happened before, I challenge my learned friends to tell me at what point will Wanjiku really propose any amendment or deliberate over the content, and that voice matters. It doesn't. three questions that the court must ask itself to understand whether this is a popular initiative or not, or whether the president can do that. Did the people participate in the formulation? Was there any awareness of the contents? Was there any content deliberation? If no, then the court must be very clear that this is not a popular initiative. It is something different. Secondly, the second reason why the president cannot be allowed to initiate a popular initiative is under the social contract theory. Now, under this theory, my ladies and my lords, we have two parties. On one end, we have the governors, that is the government, and the governed, that is the people. So when the people elect their governors, they remain at one end of that contract. The governors are on the other end. The president, in this context, is the governor, the government. The people remain as the governed. Now, in a social contract theory, it is the people who create the form of government and the framework of governance. It is not the other way around. Then after doing that, they donate the power to the governor to govern them in accordance with what they have already formulated. Therefore, the president cannot now shift goals from being a governor and now start formulating a form of governance and subject it to the governed. That would be in breach of the social contract theory. Now, just to emphasize on that point, the Constitution under Article 131(2) provides for exactly that a president will be given a constitution, he will be given an already created governance framework, and is required, number one, to respect, uphold, and safeguard that constitution. He is also supposed, under the same article, to safeguard the sovereignty of the republic. The republic is that he must recognize that these are the people who created this form of governance. These are the people who created this constitution. I have a duty to respect, to uphold, safeguard this constitution. So it is not for the president to create the constitution. It is not for the president to make the constitution or remake it. That is given to him once he enters into that social contract with the people. Now, purporting to remake a constitution will inevitably lead to him violating that duty under Article 131. Because under the social contract theory, the citizens are the right bearers and the governors are the duty bearers. So what the president has is a duty. What the people have is a right. His duty, as I've explained, is under Article 131 to safeguard that constitution. And just to ensure that the president understands this duty clearly, the third schedule of our constitution provides an oath of office, which states again as follows, that the president swears to obey, to preserve, protect, and defend the constitution. I'm only interested in one word, in those 5 words, to preserve. Ordinary English means to maintain in